Welcome to the Tax Practitioner Readiness program. This is Module 8, Part 2, which is your legal dispute resolution. At the end of this module, you are expected to understand the following: process for dispute resolution, dispute types, service timeframes, alternative dispute resolution, which is your ADR process, common errors that delays the dispute process, and also dispute resolution, which is your tax court process. Process for dispute resolution. The dispute resolution process is initiated when taxpayers are aggrieved by an assessment or not satisfied with the decision taken by SARS. If the decision is subject to objection and appeal, they have the right to dispute the assessment or decision under Chapter 9 of the Tax Administration Act. Chapter 9 of the Tax Administration Act of 2011 as amended, and the rules promulgated in terms of Section 103 thereof, that is the dispute resolution rules, provides the legal framework for these disputes across all tax types found in the various tax acts administered by SARS, excluding that of Customs and Excise Act. Disputes can be lodged against the following: interest and penalty on late payments, assessments in relation to personal income tax, corporate income tax, value-added tax, capital gain tax, dividends tax, pay-as-you-earn, including employment tax incentive, unemployment insurance fund, skills development levy, royalty tax, and any other tax administered by the tax acts apart from customs and excise and duties, and also the imposition of an understatement penalty. Dispute types: you have your request for remission, that is your RFR, administrative penalty and non-compliance. You have the notice of objection, which is your NU, the notice of appeal, which is the NOA. It should also be important to remember that when you're doing these disputes on e-filing, the system will prompt you as to which dispute you can do. So what that means is it safeguards the taxpayer from not skipping steps, which then delays the process. So if it is that you're filing it for the first time, the first point of entry would be that for request for remission, and then the notice of objection, and then the notice of appeal. So if it is the first time, you can't skip straight to the notice of objection or the notice of appeal. So e-filing will guide you in that sense. Remedies available within the dispute process: you have your request for reasons for assessment in terms of Rule 6 of the tax court rules. You also have a suspension of payment, and you have the alternative dispute resolution process, that is the ADR process. So what that means is that when you are doing the dispute resolution process, you can request for a suspension of payment as well simultaneously. So that means that your dispute will go to the department that deals with dispute resolution, and the suspension of payment will then go to the department that does the suspension of payment as well. So you can do it simultaneously on e-filing. Request for reasons. What is request for reasons? Where the taxpayer is aggrieved by an assessment issued by SARS, and the grounds provided in the assessment does not enable the taxpayer to understand the basis of the assessment to formulate an objection, the taxpayer is entitled to request the reasons for SARS assessment from SARS. How should I request the reasons? A request for reasons must be made on the prescribed form and manner, and it must be submitted to SARS within 30 business days from the date of assessment. This can be done via e-filing, via the branch office, via appointment only, and this is for your personal tax, CIT, VAT, and pay-as-you-earn. Once it is confirmed that a relevant request for reasons for assessment items has been submitted within the period which an objection must be lodged, it will automatically be extended by the period permitted by the dispute resolution process. When may I request reasons? When an original assessment, verification, or audit completed by SARS has resulted in a notice of assessment, which is your ITA 34, your VAT 217, or your EMP 217. Where request for remission, the RFR, for an account-related item has been finalized with an outcome of either allowed or partially allowed, where a decision was taken by SARS to revise an assessment. Please note, where the request for reason process is used for any other reason than specified above, the request for reasons will be declined. Request for remission, this is the administrative penalty for non-compliance. A taxpayer can lodge an RFR against their personal tax, which is PIT, or corporate income tax, CIT, for an administrative penalty assessment. SARS will issue a penalty assessment notice, that's the AP34, to notify the taxpayer of the penalties that have been levied for non-compliance. Penalties for personal income tax and corporate tax are levied in terms of Chapter 15 of the Tax Administration Act as amended. The Act prescribes the types of non-compliance that is subject to a fixed amount penalty. Request for remission, RFR, your administrative penalty non-compliance. Currently, penalties are imposed on individual taxpayers for non-compliance of income tax returns. The penalties are fixed-based. Example, a fixed RAN amount is imposed on a taxpayer's taxable income. The administrative non-compliance penalty for the failure to submit a tax return comprises of a fixed amount. These penalties are based on the taxpayer's taxable income and can range anything from 250 Rand up to 16,000 Rand per month per return. Administrative penalties recur each month that the taxpayer is non-compliant, and up to a maximum of 35 months. Each recurring penalty will have a unique transaction code. So the only way to also stop these administrative penalties is for a taxpayer to submit the outstanding returns. Although that will stop the penalty from recurring each month, the amounts it has already incurred on the account is still liable for the taxpayer to pay. Request for remission, RFR, administrative penalty non-compliance. Taxpayers can object to the imposition of certain other administrative non-compliance penalties or interest where the request for remission of such penalties or interest was not allowed or it was partially allowed. For example, late payment penalties for VAT, pay-as-you-earn, UIF, and STL. Late payment penalties on provisional tax, late payment interest on provisional tax, late payment interest on VAT, PAYE, and not UIF and STL. You have the right to object against the imposition of other tax-related penalties. Example, understatement penalty, tax-free investment penalty, employment tax incentive ETI on sectorial wage penalty, ETI displacement penalty, understatement penalty in terms of paragraph 20, reportable arrangement penalty. Notice of objection, no. What is it? It is a formal internal review process for resolving disputes between taxpayers and SARS about SARS assessments of their tax liability. Please note, you have the right to object to an assessment. You do not have the right to object to a self-assessment like VAT, PAYE. when no assessment has been raised by SARS. Notice of objection. When can I lodge an objection? An objection must be submitted within 80 business days after the date of the assessment or a SARS decision. If reasons were requested for an assessment, the objection must be submitted within 80 days after the date of the notice sent by SARS that adequate reasons have been provided and that no further reasons will be provided, or the date SARS provided you with a reason or further reasons. The notice of objection. How do I lodge an objection? A dispute management workflow process exists for CIT, PIT, pay-as-you-earn, and VAT. The dispute form to utilize is the notice of objection. This is a DISP-01, which can only be submitted as follows. Number 1, via e-filing. The DISP-01 cannot be emailed or posted to SARS. Only the electronic submission will be allowed. Number 2, at your nearest branch, and for this you need to make an appointment. Please note the ADR cannot be submitted electronically via e-filing. Submitting a late objection. It should be noted that on the landing page for disputes, there will be a section available for condonation. The condonation section needs to be completed if the objection is being submitted late. The taxpayer must provide reasons for the late submission. The grounds for the late submission will be considered first, and only if SARS is of the view that reasonable or exceptional grounds exist, will the late submission be condoned. SARS can extend the period of submission of the objection by 30 business days only if reasonable grounds exist. Where the late submission is condoned, SARS will proceed to consider the grounds for the objection and inform the taxpayer. Where the late submission of the objection is not condoned, the grounds for the objection will not be considered and the taxpayer will be informed. The taxpayer has the right to object against the decision not to condone the late submission of the objection and appeal where that objection is unsuccessful. So what that means is that if your objection is outside of the turnaround time, you need to do the condonation. You do the condonation and you do the dispute in one go. That will then be submitted to SARS. SARS would first look at the reasons on the condonation. If they are happy with those reasons on the condonation, they will then look at the dispute. If it is that they are not happy with those reasons, they will then reject the condonation and they will also reject the dispute as well. Please note, no objection will be allowed to be submitted more than 3 years after the date of assessment, or the SARS decision taken, or if the grounds for the objection are based wholly or mainly on a change in practice generally prevailing, which applied on the date of the assessment or the decision taken. Disputing interest and penalties. The following source codes must be utilized when disputing the imposition of certain interests and penalties. So you would see there's a code 9987 that is for tax-free investment penalty. Code 9990, this is the underestimation of provisional taxpayer, which is paragraph 20. Then there's the source code 9991. This is the non-submission of provisional taxpayers, which is paragraph 20, capital A. Source code 9992. This is the omission of income. Code 9988. This is the underpayment of provisional taxpayer, which is 89 quad 2. And then you have source code 9993. This is late or non-submission of a tax return. What to expect when the objection is finalized. Where the objection is allowed partially or in whole, SARS will issue a revised assessment to reflect the outcome of the objection. The notice of assessment, which is the examples here, which we have the ITA 34, the VAT 217, the EMP 217, will be issued in due course. Where the objection was in the form of a DISP 01, the notification of the outcome of the objection and the notice of assessment where applicable will be made available via e-filing. Where the objection was in the form of an ADR 1, the notification of the outcome of the objection and the notice of assessment where applicable will be made available via email or post. Does the taxpayer need to pay the amount of tax in dispute? Pay now, argue later rule. Section 164 of the Tax Administration Act. Taxpayers are required to pay tax debt before a dispute is finalized or resolved, which principle is known as the pay now, argue later. The obligation to pay tax which arises upon the issue of an assessment is not automatically suspended by an objection or an appeal. In terms of Section 164, the obligation to pay tax or the right of SARS to receive and recover tax pending objection or appeal is not suspended unless SARS directs otherwise. The taxpayer may request SARS to suspend the payment of tax or a portion thereof due to under an assessment if the taxpayer intends to dispute or disputes the liability of the tax. Suspension of payment. The suspension of payment will be disallowed if the objection is not lodged, an objection is disallowed, and no appeal is lodged, an appeal to the tax board or tax court is unsuccessful, a taxpayer is non-compliant. Appeal. What is an appeal? If you disagree with the decision made by SARS in considering your objection, you have the right to appeal that decision. When can I lodge an appeal? A taxpayer must deliver a notice of appeal within 30 business days after SARS delivered the notice of disallowance or partial allowance of the objection. This period may be extended by 21 business days if SARS is satisfied that reasonable grounds exists for the delay, or the period may be extended by up to 45 business days if SARS is satisfied that exceptional circumstances exist for the delay. How do I lodge an appeal? A dispute management workflow process exists for CIT, PIT, PAYE, and VAT and can be submitted via e-filing. Late submissions of an appeal. Where the appeal is submitted after the prescribed due date, a taxpayer must provide reasons for the late submission. The reasons for the late submission will be considered, and if SARS is of the view that reasonable grounds or exceptional circumstances exist, the late submission will be condoned and the prescribed period extended. Where the late submission is condoned, SARS will proceed to consider the grounds for the appeal and inform the taxpayer accordingly. Where the submission of appeal is not condoned, the grounds for appeal will not be considered. The taxpayer will be informed accordingly and may then proceed to object against the decision. No appeal can or will be allowed to be submitted more than 75 business days, the initial 30 plus maximum extension of 45 days, after the date of the decision to disallow the objection. What can I expect from SARS when I appeal? So you have the ADR process, which is your alternative dispute resolution. The appeal may be resolved by one of two ways, either by tax court or by the tax board. SARS endeavors to consider if a matter is suitable for the ADR process within 30 business days from the date the request has been received. Over here you can see a flowchart. This is the dispute resolution summary. So let's see. Over here you have your assessment or decision. If it is that you accept it, the assessment is finalized. In the event that you want to request the reasons and the reasons has been granted, you can either accept it or it can be finalized, or you can lodge the objection. This would be either objection allowed or objection disallowed. If the objection is allowed, you may accept it. If the objection is disallowed, you can then go either the appeal route. Service time frames. Unless otherwise agreed and when no exceptional circumstances arise that warrant an extension to the responding period, SARS will provide reasons within 45 business days from the date of receipt of the request. Make a decision on objections within 60 business days from the date of lodging an objection. Decide on the suitability of a case for alternate dispute resolution, that's the ADR process, and inform you accordingly within 30 business days from the date of receipt from this request. The following timeframes are applicable to each dispute type. Finalize ADR proceedings within 90 business days from the date of commencement of the ADR process or within a further period as may be agreed with SARS. If SARS does not concede an appeal, or if no agreement is reached after the ADR process, a taxpayer is at liberty to give notice to the tax board for consideration of the tax matter. Please note, a taxpayer may elect not to proceed to the tax board and elect to rather proceed to the tax court. In this instance, the taxpayer must file a notice in terms of Rule 25 subsection 3b, indicating that taxpayers will proceed with its appeal to the tax court. The ADR process. By mutual agreement, SARS and the taxpayer making the appeal may attempt to resolve the dispute through an ADR process specified within the rules. The ADR process is less formal, inexpensive than the tax court processes and allows the dispute to be resolved within a much shorter time period. This procedure creates a structure with necessary checks and balances within which disputes may be resolved or settled. It also creates a more cost-effective remedy for resolving tax disputes. The taxpayer must indicate in the notice of appeal whether they want to make use of the ADR dispute resolution procedures, should these procedures be available. SARS may, if satisfied that the matter is appropriate for the ADR process, and that such a matter may be resolved by using this process, inform the taxpayer accordingly. Taxpayers must within 30 business days of receipt of such a notice inform SARS whether or not they agree to follow the ADR process. Should the ADR proceedings be terminated without resolution, the taxpayer must within 20 days of such termination request the clerk of the tax board to set the matter down for formal hearing and refer the tax court in terms of section 25 subsection 3. Important rules to note. SARS must file Rule 31, this is the statement of grounds of assessment and opposing appeal within 45 days after either the date of appeal or the date of the termination of the ADR process. The taxpayer has 45 days to file its answer to this as its statement of grounds of appeal in terms of Rule 32. If the taxpayer fails to do so within 45 days, SARS may file a notice to compel the taxpayer to file within 15 days. If the taxpayer after 15 days again fails to file the Rule 32 pleading, SARS may proceed with an application to default judgment against the taxpayer without further notice to the taxpayer. If the ADR was terminated and the taxpayer elects to proceed to the tax court, the taxpayer needs to file a notice in terms of Rule 25 subsection 3 that they intend to appeal to the tax court. If this is not done within 20 days after the date of termination of the ADR process, the appeal becomes final. Common errors that delays the dispute process. Taxpayers do not stipulate the exact issues which they are filing an objection against and the legal grounds to support the objection. If this is not clear, the objection is invalidated and delays the objection process. The same applies when compiling the grounds of appeal. Failure to furnish full contact details, such as the email address, on the notice of appeal or to update the same, resulting in a delay to receive the notice in terms of Rule 13 of the Tax Administration Act. Taxpayers are not discharging the burden of proof by providing adequate requested information, such as Section 18 Capital A certificates, travel logbooks, or home office expenses. Tax court. If the jurisdiction of the appeal is less than R1 million, the matter proceeds to the tax board. The taxpayer may, however, elect to refer the appeal to tax court. This procedure creates a statutory structure with the necessary procedures within which the dispute may be resolved or litigated. The tax court appeal is adjudicated by the High Court judge and two assessors. The right to appeal to the full bench is applicable to the Supreme Court of Appeal and the Constitutional Court. The dispute can be resolved by way of settlement, withdrawal, or concession. Dispute resolution tax court process. The tax court does not have the same status as the High Court, but it is a tribunal, which is a special court created by statutes and only has the powers afforded to it by law. The tax court is presided over by judges of the High Court and appointed assessors. The tax court has jurisdiction over the following matters: tax appeals against an assessment or decision where the tax in dispute exceeds R1 million. Important tax principles are involved, which is the case test. The tax appeal is launched afresh if a taxpayer or SARS is dissatisfied with the ruling of the tax board. Interlocutory applications in respect of disputed assessments is adjudicated in the tax court before the judge of the High Court. The registrar of the tax court is responsible for the administration of the tax court. How to submit a dispute on e-filing? Please go to the SARS e-filing website. You can search for the guide on how to submit a dispute via e-filing, or you can watch the dispute process video on YouTube. Thank you for watching this video on the legal dispute resolution.